So, okay, live. All right, let me bring. All right, this is in the matter of the people of the state of Michigan versus Braxton Lamar Tyndall. I have two files, 23-21480FC and 22-21144FC. I have Douglas Hartung appearing on behalf of the people, and I have Attorney George Lyons appearing on behalf of Mr. Tyndall. Ms. Tyndall and Mr. Tyndall, your attorney has requested a breakout room, so I am going to open a breakout room and assign the three of you to that breakout room. So hold on one second.
Thank you, Ms. Angela.
You are welcome. All right, I have opened the breakout room, so go ahead and join that breakout room. Mr. Goldstein, I believe the only matter you have today is Mr. Crystal. So I'm going to bring him in. All right, Mr. Crystal, can you hear me?
Yes, I can hear you now. Thank you.
Very good. All right, this is in the matter of the people of the state of Michigan versus Alan David Crystal, file number 22-20896FH. I have David Goldstein appearing on behalf of Mr. Crystal, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial in this matter. Mr. Goldstein, how would you like to proceed with Mr. Crystal today?
Well, Your Honor, according to my notes, and correct me if I'm wrong, this matter is scheduled for trial.
It is scheduled for trial on, let me check my notes. Looks like we are set for a 2-day trial on September 13th at 10:30 a.m.
Yes, Your Honor, but I want to remind the court that I told the court earlier that I had a jury trial scheduled on Monday in Washtenaw County that I was hoping would get resolved, and it didn't, and it is going on Monday. So
Okay.
I don't think, I mean, I'm about 50-50 whether it'll be done by Wednesday. So I wanted to remind the court of that.
So, Mr. Goldstein, our juries are required to call the day before at 5 p.m. So I can do one of two things. I can get another date for the trial now, or we can wait till Monday and get verification from you on whether that trial is going to go or not. I mean, I know our trials, it's hit or miss. They usually don't go. So,
Your Honor, in all candor, that's a murder trial. And I just, number one, I'm going to be thinking about that a lot this weekend, obviously. And number two, I don't think it'll be done. So.
All right, Miss Adams, do you want to bring me the book or?
Your Honor, I'm objecting here. This is the third hard trial date I believe we've had adjourned. We have a victim who's been through the ringer with this case. She's a teenage girl, and this is really doing her a lot of damage. Just want to put that on record.
Well, Your Honor, I understand Mr. Sneed's position, and if I were the prosecutor, I would say the same thing. I would also point out that this has also been a family, including my client's 15 or 16-year-old daughter, who's been put through the ringer in this case. So it's mutual.
So what I can do though is, I mean, I have dates fairly quickly. So, that's good. Who's the judge in Washtenaw?
What's the good cause?
The good cause is I'm probably going to be in a murder trial next week.
And who is the judge in Washtenaw?
Judge Kunke.
Okay. All right. And how long is that trial scheduled for?
It should be done by, it might be done by Tuesday afternoon, but probably more like Wednesday. It's not going to be a long trial.
All right, Mr. Goldstein, you were scheduled in front of me for Victor Mendoza on September 19th. Are you available September 19th?
The answer is probably, Judge, but I do have a trial scheduled in Hillsdale for that's supposed to start on the 20th. Let me check, make sure that's right. No, actually, you know what? That trial is not supposed to start until the 21st, which is Thursday. Boy, Judge, again, it would be wedging in between two other trials, and that's just not something I want to do for Mr. Crystal.
And what are the older file numbers? Well, I understand that a murder trial of someone in custody would take precedence. Let me see here. Schedule this
The
for-
trial in Hillsdale is a case that's been set for about 3 months, and the offense took place about 1.5 years ago. I don't have a problem doing that if Judge Lisning will agree to adjourn it, but I don't think she will.
Am I the only judge that always agrees to adjourn because you have other trials? Let's see, I have Wednesday, September 27th,
27?
or I could do the 26th.
No, 27 would be perfect.
All right.
You know what, either one. I can either do the 26th or the 27th, either one.
Hey, Becky, can you look at this and tell me what this is? No, this is fine. All right, how about Tuesday, September 26th at 9 a.m.?
That'll work.
All right, Mr. Sneed,
Well, Judge, this is over my objection, so it's gonna be adjourned.
I understand that, but I, looking at the other file, that does take precedence over this file because Mr. Crystal is not in custody and it's a 2-week adjournment, so I don't think there's any harm on that. But Mr. Goldstein, obviously, Mr. Sneed will object strenuously if we have to adjourn this again. So I'm going to set the trial for two days on September 26th, starting at 9 a.m. I should have already received jury instructions. They were due by September 6th. So Mr. Goldstein, jury instructions about your questions were due today. Mr. Sneed and Mr. Goldstein. So have you both handed those in?
I'll get them in by this afternoon, Your Honor.
Mr. Sneed,
Yeah, I believe the people have, Your Honor. And what was the time on the 26th?
9 a.m.
Thank you.
Your Honor, there are a couple of other issues I'd like to address when the court's ready.
Okay, I don't have jury instructions to provide your questions from either the people or the defense on this. All right, and what else would you like to address today, Mr. Goldstein?
Your Honor, there is a little issue with discovery, potential issue with discovery. Both the complainant in this matter and at least one of the witnesses on the people's witness list were interviewed in a forensic interview. I have never been provided with a copy of the recording of that interview. I do have the summary. That's why I haven't really made much of an issue of it up until now, but I do not have a copy of the recording. That's one.
Right. Mr. Steen, are you able to provide that?
We may need a court order, Judge, and if so, I'll follow up the court.
I believe an order was prepared by Miss Borders before she left. I could be wrong about that.
All right, let me look.
I thought she did, but it's been a long time, so.
Okay, so, the people will provide, a recording of the forensic interview of the victim in this matter.
And there is a witness who was also interviewed named Elise Crystal.
Could I have the initials of both individuals you're asking for a copy of the interview?
The initials,
Yes,
EC.
please.
EC, and the complainant.
Okay. All right, I've written that in my scheduling order.
Now, as far as the trial itself is concerned, Your Honor, Mr. Sneed mentioned a few moments ago about the emotional, I'll just use the word trauma that people have gone through as a result of this case. And that includes Elise Crystal, who is my client's daughter. As a result of the accusations made by the complainant and her treatment since then, she has been in therapy. So we're asking if the court would allow two things. One would be a support person in the courtroom while she's testifying. The problem is it cannot be her mother, because her mother is also endorsed as a witness. And I'm assuming there'll be a sequestration order. So we're asking if the court would allow a third-party support person in the courtroom while Elise is testifying. And the second half of that is that I suspect that the complainant, Robin, will testify before Elise does. I mean, that's up to Mr. Sneed in what order he decides to call his witnesses. But my client my client and Elise have asked if Robin not be in the courtroom while Elise testifies.
Mr. Sneed, does the division, the victim advocate division that you have, provide a support person for testimony of victims?
I believe somebody from our office could serve in that role, Judge.
Mr. Goldstein?
Or the family could provide one. As I said, it can't be the mother because she's an endorsed witness. But the family, I think, if not, I'll contact Mr. Sneed and make arrangements through him for someone from their office.
All right. Any objection, Mr. Sneed, to a support person being present during the testimony of EC for her benefit?
Not in general. I think it would just depend upon who the person may be, whether or not the people would object. So I withhold that. I think Mr. Goldstein and I could work it out, however.
Okay. And the complaining witness, R, is her last initial C as well?
W.
W? Okay. Let me write that in. All right. So Mr. Goldstein, Mr. Sneed, the two of you can agree on who that support person will be. And I filled out a scheduling order and we will get a copy of that out to everybody. All right. Anything else we need to address in this file, Mr. Goldstein?
Well, Your Honor, I was going to ask the court to reconsider the issue of bond, but because I anticipated this might be a long adjournment, given that it's only 2 weeks, I think I'll hold off and not argue bond today. Let's get this file done.
I
right,
want to ask you,
Mr.
Judge, the people had filed jury instructions and voir dire back on August 23rd, so they just might not.
Awesome. All right. They just haven't made it to me yet. Very good. All right. So Mr. Goldstein, you can file yours today, and Mr. Crystal, we'll see you back on September 26th at 9 a.m. for trial. Thanks. Thank you all. All right, Mr. Crystal, you're all set.
Thank you, Your Honor.
Thank you. All right. Jill. All right, so if you're in the courtroom and you have a case today, raise your right hand. Okay, so I know who you are. Who are you? Norton. Norton, okay. This. All right, Mr. Al-Muhammad, Miss Underwood is next door first. Okay. So I will make a note, and when she comes in, we'll take you. And Mr. Norton, why don't you step up to the podium? You have Mr. Murphy. Okay. Yep. Mr. Murphy.
Morning, Your Honor.
Morning. Okay, This is in the matter of the people of the state of Michigan versus Daniel Philip Norton, file number 23-21382FH. And Matt, or let me see, this is my prosecutor. I'm gonna go with Isaac Sneed appearing on behalf of the people, and I have Matt Murphy appearing on behalf of Mr. Norton. Mr. Norton, in my file, I have an order for fingerprints that were supposed to be done at the, let's see, looks like it was an arresting agency was APD, but I have an order for you to go get your fingerprints done at the jail. Have you done that?
No,
Okay.
I wasn't aware of it.
Well, I ordered it the last time, it looks like on June 13th. So I'm gonna give you a copy of this order. And when you're done here today, I need you to go to the jail and get that done, all right? If they say we can't do them, you need to go to APD, you're gonna have to call Adrian Police Department because they do fingerprints, I think, 2 mornings a week, all right?
Yeah.
Okay, all right. So, Mr. Murphy, how would you like to proceed today on behalf of Mr. Norton?
Your Honor, in regards to Mr. Norton's case, my understanding is the prosecution right now, their offer is still, I think it hasn't changed. They haven't changed it. It's for as charged, no habituals on the felony file. The felony charge dismissed, the misdemeanor, retail fraud, second, and trespass. I wanted to ask Mr. Norton if I could speak with, well, if I could speak with him in a breakout session. I wasn't sure what Mr. Norton wanted to do today with that offer.
Are you in your office, Mr. Murphy?
I am. My lights
Okay.
are off, so it's kind of dark.
It's okay. So Mr. Norton, Mr. Murphy would like to speak to you. You got 2 options. You can go in the hallway, take a left and use the remote device.
Right.
In the hallway, it'll give you instructions, or you can step across the street to his office. What would you like to do?
Go down the hall.
Okay, so go out the doorway, take a left, you'll see a stand with an iPad on it.
Okay.
Follow the instructions. If you can't do it, pop back in and I'll send somebody over, all right? Okay. Miss Adams, I have the jail, but there's nobody, or it's turned off, but I do have Michael, wait, do I? No, I do have, I have nobody. Oh, Mr. Bennett. So I'm ready for Gary Shumate from the jail. And then you can let the jail know we don't need Christopher Lake today. And then, all right, Mr. Vito, I have Mr. Klein. Let's bring him in.
Morning, Your Honor.
Good morning. 1 second, let's get him in here. I'm just kind of stuck trying to join. All right, Mr. Murphy, got a client, so I'm gonna assign him and you to a room. Maybe. All right, you should have gotten an invitation to join the breakout room, Mr. Murphy, in the hallway. There you go. All right. Mr. Klein is stuck in purgatory right now. Says he's joining, but he seems stuck. Mr. Klein is connecting to audio. All right, Mr. Beaverson, I just wanted to let you know, I do know you're there. I'm waiting for Mr. Glazier. He's probably in front of Judge Olsaver right now. And when he's done, we'll come back to my court, okay?
Okay.
So I'm gonna pop you in the waiting room. And I put his initials after your name, so I know that you're his client. All right, Mr. Murphy. All right, Mr. Klein, I'm gonna ask you to unmute your device.
Okay.
All right, this is in the matter of the people of the state of Michigan versus Benjamin J. Klein, file number 23-21327FH. I have Matthew Vitito, P71585, appearing on behalf of the defendant, and I have Christopher Fleming, P75946, appearing on behalf of the people. This is the date and time set for a pretrial. Looks like this is our second pretrial or third pretrial. So, Mr. Vitito, how would you like to proceed today?
Your Honor, I'm just asking for a new pretrial date. I'm preparing a motion to suppress and a couple other motions, and would just like a new date, please.
All right, so Mr. Klein is not in custody. How about October 18th at 8:30 a.m.?
That works for my calendar. Thank you.
All right, so I'm going to schedule another pretrial October 18th at 8:30 a.m. That'll give you plenty of time to file a motion and set it for that date as well. Mr. Vitito, can you prepare the stip in order to adjourn the pretrial? And Mr. Fleming, can you sign your name with permission?
Absolutely, Judge.
All right, and just for my notes, Mr. Mr. Klein is charged with operating while intoxicated, third offense. Has there been a plea offer made in this file? Just because I like to keep notes.
There has been no offer made.
All right, very good. So Mr. Klein, I'll see you back on that date and your bonds continued. Thank you.
Thank you, Your Honor.
You're all set, Mr. Klein. You can go. There it goes. All right. All right. So, Mr. Murphy, I have Mr. Norton back. Why don't you come back up to the podium? So, Mr. Murphy, this is the date and time scheduled for the first pretrial conference in this case. I have provided Mr. Norton his order to get his fingerprints done. Mr. Murphy, how would you like to proceed today?
Your Honor, at this time, since it is the first pretrial, the case isn't too old. I'd ask for a setting of another pretrial. If the court will be okay with that. I think that we can get the case resolved hopefully by that pretrial. I may end up scheduling a COPS conference if necessary before then. I don't want to schedule a trial right now. I think, again, maybe another pretrial will be more appropriate for that.
All right, so Mr. Norton, I'm going to set this over for a pretrial on October 11 at 8:30 in the morning. Ms. Adams, could I get a notice of hearing from Mr. Norton since he is present in person? So Mr. Murphy, we will prepare the notice of hearing on that. So Daniel Norton, Ms. Adams, October 11th at 8:30. Mr. Norton, if you can have a seat at that table, we'll get you a notice of hearing for your next court date and your bond's continued. All right.
Thank you.
You're welcome. All right. Who do I have joining me from the jail?
Mr. Shumate.
All right, Mr. Shumate, let me grab your file. All right, Mr. Bennett, I do have your client. So this is in the matter of the people of the state of Michigan versus Gary Edward Shumate, file number 23-21507FC. Hold on 1 second, let me get them. Yeah, Mr. Bennett, there you are. All right, Mr. Bennett or Mr. Bennett is appearing on behalf of the defendant, and I have Isaac Sneed appearing on behalf of the people. This is the date and time scheduled for arraignment in this matter. Mr. Bennett, do you waive the reading of the felony information?
Yes, Your Honor, I would acknowledge receipt of the information. We would waive its formal reading and ask that the court enter a not guilty plea on behalf of Mr. Shumate.
All right. Have you received a copy of the prosecutor's request for discovery and witness list?
Yes, I have.
All right. And at this time, Mr. Bennett, do you wish to, is your client going to enter a plea, or is he going to, are you requesting a pretrial date?
Your Honor, I'm requesting a pretrial date. I would indicate that there's another case that's set for a final pretrial on the 27th of October. I spoke with Ms. Wise quite a bit actually about this case. We're going to probably want to move that. I don't know if you want to put this pretrial on that date. I believe she's going to attempt to consolidate it, and she's going to file 404B notices in both cases.
So I do not have it set on October. You said October 27th?
I'm sorry if I did, I misspoke. September 27th, Your Honor. Trial date's set for October 3rd in that case.
So I can set this one over to September 27th with his other file. That's fine. Are you all right with that, Mr. Bennett?
Yes, I am, Your Honor.
Okay, so I will set this for pretrial on September 27 at 8:30 in the morning. Because it was arraignment, my staff will prepare the notice of hearing, and then Mr. Shumate will have all your files together on that same day, okay? Did you hear me, Mr. Shumate?
Yeah,
Gary, did you hear that?
All right, so Mr. Shumate, we'll see you back on all your files on September 27th at 8:30 in the morning, okay? And the court will enter a plea of not guilty on your behalf. Thank you.
okay.
Thank you, Your Honor.
Thank you. All right, Mr. Let's see. All right, so we are back on the record in the matter of the people of the state of Michigan versus Braxton Lamar Tyndall. Mr. Lyons, have you had ample opportunity to speak with your client?
Your Honor, I have spoken with both my client and his mom. We are going to
Yeah, I'm done.
All right, hold on, this is the jail making noise. Hold on, let me put the jail in the waiting room. Okay, I'm sorry. Go ahead, Mr. Lyons.
no problem. Without going into detail, my client is amenable to sitting down and addressing the issues that we discussed with the court prior to going on the record with Mr. Hartung and myself. So we would be asking for an adjournment to facilitate that. Does that sound fair, Doug? Doug, you're on mute.
Mr. Hartung, you are muted.
Yes, sorry, that's fine, Your Honor. I would suggest maybe 45 days to put in play what we're talking about doing.
Right, so Mr. Lyons, are you asking for a bench conference or a pretrial? I want just to clarify.
Both.
Yeah, both would be fine.
Oh. Okay, so why don't we do this? Why don't we set a bench conference and then a follow-up pretrial? Is that all right?
Sounds good.
Okay, so it's beginning of September, October. So, all right, so I could do a bench conference Tuesday, October 17th at 8 a.m. via Zoom.
Okay. That sounds good to me. And I'm going to do this for both files, Your Honor.
Yes, that would be for both files. We'll do that at 8 a.m. and then I can set him for a pretrial on October 18th. Is that good?
That sounds good.
Or
to
do you
me.
want a pretrial a week later so you have more time to speak with your?
No, Your Honor, if things go the way that that I think they may go, that should be sufficient.
I'm good with that.
Yes. All right. Your Honor, may I address the issue
Oh,
of bond?
no, hold on, my Polycom disconnected. I apologize. So, Mr. Lyons, I can do a bench conference, as I said, October 17th at 8. And I can do either a pretrial the 18th or the following Wednesday, which would be the 25th, if you needed more time to be able to speak with your client.
No, I'm good with the 18th because I think I have plenty of time to talk to my client prior to that, given what our plans are.
Okay, so I will set a bench conference for October 17th at 8 a.m. And that would be with the attorneys and myself, and then a pretrial on October 18th at 8:30 in the morning. And Mr. Lyons, you'll do the step in order to adjourn those dates?
Yes.
Okay, Mr. Hartung, can you sign your name with permission?
Absolutely.
All right, very good. All right, so Mr. Tyndall, as well as Ms. Tyndall, I'll see you back on October 18th at 8:30 in the morning, okay?
Your Honor, may I've talked to his mom and she's asked me to address bond. I know the court has concerns, and I know the court has kind of been over backwards in this matter. But given the nature of where we are and what our plans are and what our intent is, and the fact that he's located almost 2 hours away, which is very difficult for a single mom to get up to see her son, we're asking for the court to consider a reasonable bond with tether and house arrest, as it were, if the court is of a mind. Just given where our plans are at resolution, it may be a more viable way to go about this, Your Honor.
Mr. Hartung, your response?
Well, I am not ready at this point in time to agree to a bond reduction. If the court to do that, the court obviously has that authority, but I don't think it's appropriate yet. We may well be in a position to discuss this a little further down the road moving forward, but I think this is premature. There's a concern about the community. There's a concern about, quite frankly, there's a concern about Mr. Tyndall's health and safety as well. And I've said this for all the people that have been involved in this little back and forth feud between these defendants and co-defendants throughout this matter. We got to keep this young man alive, and we got to keep the other people safe. And the one thing that does bother me, obviously, is the first charge here, the armed robbery charge, was committed, and this newer set of charges was committed while Mr. Tyndall was out on bond for that charge. So I think it's really premature at this point in time to start talking about reducing the bond.
So, Mr. Tyndall, you were on bond in my court for armed robbery and felony firearm, both of which carry life in prison, or count one carries life in prison if you were convicted. Your attorney worked really hard and was meeting with Mr. Hartung to find a global resolution that would give you an opportunity to turn the path your life was on. And while on bond, you are now charged with assault with intent to murder, a discharge, enter at a building of a firearm, and felony firearm. Once again, life offenses, which would stack on your original charges. So, Mr. Tyndall, your age obviously is one of the concerns that Mr. Lyons has addressed, but the charges you committed or the charges against you are adult charges. So you may be a young man, but these are very serious charges against you. And I agree with Mr. Hartung. I also would be concerned about your safety in public. Now, I had you based on house arrest, and you obviously weren't paying attention to my requirements. So I am going to deny your request for bond at this time. We'll see you back on the 18th, Mr. Tyndall and Ms. Tyndall. Thank you.
Thank you.
Thank you, Judge.
Thank you, Your Honor.
Love you, Mom.
All right. Mr. Glazier, I have Mr. Beaverson. Oh, wait. I lost him. I don't, no, he's up there. And Mr. Locke's up there. All right. Mr. Glazier, hold on 1 second. Let me get Mr. Beaverson. There he is. Mr. Beaverson, you can hear me?
Yes.
All right. So. File. Mr. Glazier. All right. This is in the matter of the people of the state of Michigan versus Greg Darrell Beaverson. File number 21-20238 FC. I have John Glazier appearing on behalf of Mr. Beaverson, and I have Phoebe Neer appearing on behalf of the people. This is date and time set for a pretrial. So let me find you on my docket. Okay, Mr. Glazier, how would you like to proceed today?
Your Honor, we'd ask to have this set for a trial.
All right. I also have filed on August 8th of 2023 the prosecution's notice of intent to use other act evidence. You received that as well, Mr. Glazier?
I do, Your Honor. We would object to the use of that as well.
Are you going to file a response then, I'm assuming, and set it for hearing?
Yeah, you can set it for hearing.
You can file a response and set it for hearing. Okay. All right. So how many days do you need for trial?
Probably at least 3.
Would you agree with that?
I mean, I haven't received a witness list from defense, but based on the people's witness list, I would say no more than 2.
I think we'll have a few witnesses, Your Honor. To be safe, I would set it for 3, but that's up to you.
That I'm fine with that, but one of the issues I'm having at this point is apparently there's some defense discovery that previous counsel had that I have not seen. I think maybe it was between him and Miss Borders. I don't know if Mr. Glazier has it all or not, but that's something I reached out to Mr. Glazier and attempted to meet with him on, and we just haven't been able to do that, I guess. So I'm asking for defense's discovery at this time.
Okay. And did you
And
file a
witness
request? Okay. All right.
We did do a request for discovery, obviously with our initial information.
Okay. So Mr. Glazier, sure. Let me see. I'm looking at. Trial. Miss Adams, can I have the 24 book, please? Looking and I don't see anything. See anything? Pretty backed up on trials. So I am looking at I am looking at Tuesday, January 23rd. That gives us ample time if it's the last 2 days or 3 days for jury as well. Are you available Tuesday, January 23rd?
Yeah, I'm available, Your Honor.
Miss Meir? Okay, so I am going to require that jury instructions and voir dire questions are due by January 15. Now, it's my expectation that you will meet and go through and agree on what you're able to agree on, and anything that's left in dispute, we will address at the final pretrial on January 17. I'm going to require that all motions be filed and heard by January 3rd. I'm going to mark in the scheduling order. Was there a preliminary exam held? Yep, I've got a transcript already.
Yep, and you actually, this has been set for trial a couple times, so you should have all the jury instructions more dear, but I'll definitely check on that and file updated if needed.
All right, and then all exhibits have to be marked in advance of trial, and attorneys shall submit a list of marked exhibits at least 3 business days before trial. However, at least 1 week before the final pretrial conference, each party shall make available all exhibits which that party may introduce at the trial, so there's no surprises. And Mr. Glazier, note, the people have an outstanding request for discovery. I know that you probably were dealing with Ms. Borders at one time. Make sure that they've received everything and vice versa. Is there anything else we need to address today?
No, Your Honor.
Ms. Meir?
No, just like I said, a defense witness list as well.
Okay, so Mr. Glazier, you'll make sure that's filed. It might have already been filed, I don't know. All right. So I will see you back, Mr. Beaverson, on January 17th of 24 at 8:30 in the morning. I've done a scheduling order, so you won't need to do a notice for today. All right, very good. Thank you all.
All right, thank you, Your Honor.
Thank you.
Thank you. Rhonda Underwood, I have Mr. Muhammad here. So why don't you come up to the podium? So find you here. This is in the matter of the people of the state of Michigan versus Ahmed Abdul Kareem Muhammad. We have 2 files, 22-211. 66FH. Mr. Beaverson, I'm going to help you on your way there. I'm getting some. There he goes. 22-21166FH, 23-21453FH. I have Rhonda Underwood appearing on behalf of Mr. Muhammad, and I have Isaac Sneed appearing on behalf of the people. Mr. Rembert, I will be with you in just a moment. So, Ms. Underwood, we've had, let's see, he's here in person. So this is 1, 2, 3, 4, 5, like 5, 5th pretrial, I think, on this file. I have the plea offer is to plead to attempted RNO and disorderly on 22-21166. See, it's on the other file. And what, I don't know if there was a plea on 23-21453.
Your Honor, it would probably be better. I'll be up right now.
Okay, so she's on the next floor, so she's just gonna pop up, all right? Okay. All right, so I will set this one to the side. Mr. Rembert, you still in there? You can sit back there. She's probably gonna come up and take you out in the hallway. All right, Mr. Rembert, let me see if I have your file. Ms. Adams, Did I leave the box? Oh, nope, you gave it to me already. Excellent. Okay, so this is in the matter of the people of the state of Michigan versus Milton Trey Rembert. We have multiple files, 23-21276FH, 22-21090FH, and 22-21191FH. So, Mr. Rembert, we are here on a violation of a request and warrant for probation violation. Mr. Moore is present in the courtroom. The allegations against you are that you violated your articles of probation dated June 11 of 2020, and that you tested positive for the controlled substance methamphetamine on September 5 of 2023, and admitted to using methamphetamine a few days prior. So, Mr. Rembert, do you understand that's the alleged violation against you? So you are muted, so I'm going to send you a request to unmute. Can you, is there a, yeah, why don't you unmute that? Mute it, thank you. So do you understand that's the allegation against you, Mr. Rembert?
Yeah.
Okay, now, Mr. Rembert, you're on probation on 2 of these files for police officer assaulting, resisting, and obstructing, which carries a maximum penalty of up to 2 years in prison if you plead guilty. And then on 1 file, 22-21191FH, you're on probation for failure to stop at the scene of an accident. Is that correct, Mr. Moore?
Yes.
So that offense, if you plead guilty or found guilty, could blah, 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 could carry up to 5 years in prison if you plead guilty or found guilty. Do you understand that, Mr. Rembert?
Yeah.
All right, Mr. Rembert, you are entitled to have an attorney represent you here today or any subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
Yeah.
All right. Mr. Glazier and Mr. Murphy, Mr. Rembert is in jail and he is got my jail window. Would one of you like to talk to him from Miss Underwood until she gets done with her client, or?
Yeah, I can do that, Your Honor.
All right. So, Mr. Rembert, did you hear the charges against Mr. Rembert, Mr. Murphy?
Yes, Your Honor.
All right. So, Mr. Rembert, I'm going to put you in a breakout room with Mr. Murphy real quick to talk to him. So, hold on. All right, so I'm going to remove, all right, should have gotten an invitation to join a breakout room.
Morning.
Morning, Mr. Moore. All right, so I appreciate Mr. Glazier, Mr. Murphy doing that because it'll move my jail window. All right. So while they're doing that, Jeff, I'm gonna let everybody take a 2-minute break.
Thank you. Looks like it's gonna be raining out there pretty quick.
Yeah, you still live.
We could use the rain.
Yeah, man, they keep this, this week. I was out working, it was okay.
Well.
Yeah, I put it.
Ooh. Yeah, I work in my yard. Thatch it.
Oh,
I got a small yard. So.
yeah. Keep it.
Well, yeah. I was really seeing that house in Toledo. It was a big yard. I had some help. This one's light and small. It's easier.
Yeah.
Makes me want. I use it to go 2 hours before. Pardon me?
I have a question.
Go ahead.
Let's get more order.
Yeah.
I got it.
Okay.
There's a judge or
Just. You know what? That was quick.
yeah, I got it done.
Take that down to the clerk's office. They'll take it down there.
Clerk.
Yes.
Okay.
All right. Thank you. Have a good one.
Yeah, I'm actually using. Right. 6, 8. But I got pasture. Well, it's 2 hours. Yeah. So is that is used to find
In the right.
yes.
Is that it?
Yeah.
No.
That's definitely. We still have horses.
All right. Good point, Jack. Thanks. Mike. Yeah.
You see more of us now because now it's
All rise.
You should be seated. Except you, Tom, you're gonna sit in. All right. All right, thank you, Matt Murphy. You just got your message. Okay, so real quick, let me pop over to this one. So Mr. Murphy, have you had a chance to speak with Mr. Rembert?
Yes, Your Honor. At this time, Mr. Rembert wishes to take responsibility and plead guilty to the violation of probation.
Okay, so Mr. Rembert, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yeah.
All right, so Mr. Rembert, you had asked for court-appointed counsel. I appointed Mr. Murphy to represent you. Have you had ample time to speak with Mr. Murphy?
Yeah.
All right, Ms. Underwood, I appointed Mr. Murphy because Mr. Rembert's in my jail window and I wanted to keep the jail window moving, and Mr. Murphy was kind enough to do it for you.
Thank you, Your Honor.
All right, so Mr. Rembert, and you're satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yeah.
All right, so Mr. Rembert, do you understand that you have a right to contest the violation of probation charge and to have a trial on it? You understand that?
Yeah.
Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, ma'am.
All right, you have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you have to appear at your trial. Do you understand all of that?
Yeah.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
You do not, on the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, ma'am.
All right, so Mr. Rembert, how do you plead to the charge that you violated the terms of your probation on each of these files by testing positive for the controlled substance methamphetamine on September 5 of 23 and admitting to use of methamphetamine? Guilty or not guilty?
Guilty.
All right. All right. Do you understand by pleading guilty, you'll be giving up the right to a trial? And as I've already explained to you, Mr. Rembert,
Yeah.
has anything been promised to you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record during this hearing, that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Mr. Rembert, you were placed on probation on these 3 files. And one of the terms of your probation is that you weren't to use any illegal controlled substances. Is that correct?
Yes, ma'am.
All right, so on or about September 5th, you came in to report to Mr. Moore, is that right, yesterday?
Yes, ma'am.
And when you tested positive for methamphetamines. Is that because you had used methamphetamine?
I have used it a couple of days prior.
Okay, but you weren't allowed to use methamphetamine, is that right?
Yeah.
And you didn't have a prescription or a legal right to use methamphetamine, right?
No.
Okay, all right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for an updated probation violation report.
Your Honor, what I would like to do, and I spoke with Agent Teskey, and I had a conversation with him yesterday regarding treatment. He was interested in going to an inpatient program, said he was planning that prior to coming in to see me. Not necessarily, but Agent Teskey would like to interview him for potentially drug court and or getting him in place in the inpatient. So if we had a little bit of time for that,
okay,
I can do that.
So Mr. Rembert, Mr. Moore said that you would express some interest in either being screened for drug court or entering into an inpatient program for treatment. Is that true?
Yes, so drug court is when you gotta come in constantly and get drops.
Say it again for me, please.
Drug court where you come in constantly and get drops.
I don't know that you come in. You could be tested up to twice a week. It's a pretty strenuous program because, we're trying to help people with severe drug addictions to overcome them, and testing does keep people honest. So they help you find housing, they help you find a job, which makes it easier to pay for the testing. But then also inpatient is usually one of the first steps. So if you are screened for drug court and admitted, you will probably go to an inpatient program first, and the drops are part of that program. And then if you join the drug court program, yes, you could be testing up to 2 times a week.
All right, that's fine.
All right, so you want to be screened for drug court?
Yeah.
Okay, so what I'm going to do is I'm going to set this violation of probation sentencing out 2 weeks. So I'm going to set it out to September 22nd at 8:15 in the morning. Let me double check my book. Yeah, I'm gonna, so September 22nd at 8:15 in the morning. Ms. Teskey will come meet with you, or Ms. O'Connor from CMH. To screen you for drug court. And then we'll see you back on September 22nd at 8:15, okay?
Is that for sentencing or something?
Say it again.
Is that for sentencing?
That would be for your VOP sentencing, yes.
Okay,
All right, thank you, Mr. Rembert, you're all set.
thank
Judge,
you.
Judge, is
Thank you,
that,
Mr. Rembert.
is that Zoom?
Mr. Rembert, can we do the sentencing via Zoom, or do you want to come in person?
Zoom?
Okay, I'll put it down Zoom, thank you.
Okay.
Thank you.
Okay, thank you, Mr. Moore. All right, Miss Underwood, let me get your client. Okay, so we are back on the record with Mr. Al-Muhammad. So, Miss Underwood, have you had a chance to speak to your client?
I have, Your Honor.
All right.
Your Honor, Mr. Al-Muhammad has 2 files up here, and he currently has 1 file awaiting a preliminary examination downstairs. However, we are experiencing some movement on these issues, Your Honor, after a long time. So I am not without hope that we are nearing a resolution in this matter, in these matters. Mr. Al-Muhammad does have issues with immigration that we need to be extremely cognizant of how we resolve these issues. So I would ask for maybe a month adjournment, Your Honor, and hopefully we can have everything.
Right.
I realize the court has been very patient, but as to the second file up here, we don't even have the transcript for that one. We have the first one, we don't have the transcript.
Okay, so Mr. Sneed, any objection to setting this out at least another month?
No objection, Your Honor. Thank you.
All right, October 18th, Miss Underwood?
Thank you.
All right, so I will set this out for another pretrial on October 18th at 8:30 in the morning. Ms. Adams, could I have a notice from Mr. Al-Muhammad on both of his files? And, okay, so October 18th at 8:30 in the morning, and you're welcome in person or Zoom. Where's your citizenship?
I don't have no citizenship. Yeah. I actually couldn't get it right after I caught my first felony.
No, where is the immigration concern? What country?
Iraq.
All right, so, I don't know, that's a lot. Okay, so we'll see you back October 18th at 8:30 in the morning, and Miss Adams will get you a notice. So I have a seat right there, and yeah. Okay. All right,
Your Honor, can I ask, I have 3 MDOC files scheduled.
I got nobody.
I'm wondering if I'm batting 0 for 3 this
All right, so, all right, in the matter of the people of the state of Michigan versus Darnez, Donald Johnson, that's one of them, right? Yes.
Yes.
Miss Adams, is Mr. Johnson the one we received a phone call on?
Yes, and I never got a response back.
All right, so, and that is file number 22-20959FH. I have Rhonda Underwood appearing on behalf of Mr. Johnson. And I have Christopher, I don't know, I got Mr. Sneed, I got Mr. Fleming. I got Mr. Fleming appearing on behalf of people. My office received contact from Michigan Department of Corrections. They stated that Mr. Johnson was under observation. They wouldn't tell us what that meant. We don't have any definitive information, just that they said he wouldn't be appearing today. So a writ was done. They just are not going to produce them today. So Ms. Underwood, I don't know what that means. I don't know if it's mental. I don't know if
It's mental.
Okay, so I can set this out to October 25 at 8:30 in the morning, and maybe we'll get them back. So I'll do a pretrial October 25 at 8:30 in the morning. Can you do the stip in order to adjourn?
I will do that for Mr. Fleming today, Ron.
Well, he did a writ, so I only make him do it if there's no writ.
I'm feeling that, you know, he did his writ, so.
You could sign my name to that, Miss Underwood.
Thank you very much.
All right, so on that file, we'll do that, and let's see, Ms. Underwood, he had
Mario Armour and Terrence Freeman.
Hold on, let me go. All right, so see with that. All right, so in the matter of people of the state of Michigan versus Mario Cornelius Armour, file number 23-21339 FH. I have a stip in order to adjourn the pretrial to July 26th at 8:30 in the morning. That's the last thing I have in the file. So I might be missing a stip in order to today, maybe. And then I have a letter from the Center for Forensic Psychiatry dated July 18th, saying we received your orders for evaluation dated November 21 of 22. The address competency on January 5, and criminal responsibility was conducted on July 18th of 23 at Bellamy. We will issue a report as soon as possible. So I have not received that report.
I have not received it as well.
All right, Mr. Sneed, have you received that report?
No, we have not.
Okay, so we're waiting on that report. So why don't we set this one over as well to October 18th at 8:30 in the morning?
And I will do that stip and adjournment as well.
Yeah, so let me take care of that. 8:30 in the morning. Okay. Then we have Mr. Spearman. All right, in the matter of the people of the state of Michigan versus Terrence Ray Malik Spearman, file number 23-21348 FH. Ron Underwood appearing on behalf of Mr. Spearman. I have Isaac Sneed appearing on behalf of people. So I do have a stip in order to adjourn to today. I do not have a writ for today, though. Mr. Sneed, do you have a writ for today? I see one for the 26th, but not today.
I'm checking the file right now.
Ms. Adams, I don't know if that jail is doing anything, but I will take Jason Opal.
Okay.
Your Honor, I have Nicholas Schmidt in my office. Can we do that arraignment?
Yep, I'll do that one next.
It looks like our last writ for Mr. Spearman was for Wednesday, July 26th.
Okay, all right, so I'm gonna set Mr. Spearman over for pretrial on October 18 of 23 at 8:30 in the morning. And Mr. Sneed, you can do the stip in order to adjourn that one. Ms. Underwood, can you sign your name with permission?
He certainly can.
Excellent. So we'll need that in the writ. All right. So your guy in jail, I'm waiting on him. I'm going to take care of Mr. Schmidt.
Do we have any other pickups, Your Honor?
No, I just had that one and I just wanted to keep, I didn't mean to take it away from you. I just wanted to keep the jail window open.
Well, I apologize to Mr. Murphy that I wasn't here, so he was drafted.
That's okay. All right, so Mr. Murphy, in the matter of the people of the state of Michigan versus Nicholas Thomas Schmidt, file number 2023-21502FH. I have Isaac Sneed appearing on behalf of the people. I have Matthew Murphy appearing on behalf of Mr. Schmidt. This is a date and time scheduled for arraignment in this matter. Mr. Murphy, do you waive the reading of the felony information?
Your Honor, at this time, we waive a reading of the information. We acknowledge receipt of said information, the witness list, and the discovery demand from the prosecution. At this time, we are asking for an entrance and continuation of a not guilty plea and a setting of a jury trial in this matter. At the preliminary examination, the prosecution withdrew all offers of negotiations before the exam started. So we reserved the speedy trial right downstairs, and we want to reassert speedy trial right up here as well.
Okay, did you file you had a preliminary exam?
Yes, Your Honor.
Did
We have
you
not
file a
filed for, I'm sorry,
Did you file a request for a transcript yet?
not yet, Your Honor.
Okay, so you're gonna do that, and there's a 90-day wait on transcripts, so. December, January, all right, so we are scheduling, for January, you're gonna need that transcript, so. You said a jury trial, right?
Yes, Your Honor. I think it'd be safe to schedule for 2 days. It might only take one, but I think it might take two. So I'd ask for maybe a 2-day jury trial.
All right, I can back it up to Ryan Crafts. You have scheduled for 2 days, January 9th.
Can we do that, Your Honor, please?
Sure. All right, so I'm going to schedule it for January 9 of 24 at 9 a.m. And then I'm going to set a final pretrial for December 27 of 23 at 8:30. I'm going to require jury instructions and voir dire questions must be handed in by December 19th. I know, Mr. Sneed, you're appearing on this, but you don't typically do the CSC trials, right?
I believe it's Miss Mears' case, and she's
okay. Okay. And I will make motion deadline to be filed and heard by December 27 of 23. Right, and you waive the reading of the information, so I will enter a plea of not guilty on behalf of your client. Mr. Murphy, you did receive a copy of the felony information request for discovery and witness list?
Yes, Your Honor, we acknowledge receipt of those. I was asking also if we could address bond when the court's ready.
Yep, give me 1 second. Okay, you can address bond.
Yes, Your Honor, thank you. Mr. Schmidt does have an order of no contact with anyone under the age of 18 on this case. There is an exception for he is allowed to have, district court did allow him to have supervised visits with his son. I'm asking the court to consider removing the no contact provision of no contact with anyone under the age of 18. The complaining witness in this matter was 21 when the event occurred, is 22 now. I don't see any history of criminal history of Mr. Schmidt that's like this case. He does have one prior OWI from almost 20 years ago. So he doesn't have a history of this He doesn't have any history of anything that would cause concern for anyone under the age of 18. That would spawn purely from this case. And again, the complaining witness is not under the age of 18. It is his daughter, but again, she was 21 when the alleged incident occurred. So I'd ask the court to consider removing that. I don't believe that Mr. Smith posed a threat to society, a threat to anyone under the age of 18 or anyone at all. So I'd ask the court to consider removing that no contact provision.
All right, Mr. Sneed or Mr. Fleming, somebody want to weigh in? You're both on.
Yes, good morning, Your Honor. Chris, I'm appearing on behalf of the people. This is actually my case, Judge. Just a brief summary. This case involves the defendant sexually assaulting his daughter while she was incapacitated sleeping. I believe for the protection of public that it is imperative that we do not allow contact with minors at this time. I think if he's willing to do this to family members, that minors would be more likely to be victimized in this manner. And I believe that would be, he's essentially asking for contact with his, I believe, son. So I think that would put him at risk. So people would ask that that be denied.
Mr. Murphy, any response?
Yes, Your Honor. When the incident did occur, it was at the preliminary examination established that the complaining witness did leave her 2-year-old daughter with Mr. Smith, his granddaughter. There was no concern about that. There was no incident involving his son. There was no allegation involving his son or anyone else other than this incident. Obviously, the facts of the case, we're not going to get into that here because it is set for a jury trial. However, I do believe that when you look at it, again, Mr. Smith doesn't pose any threat to anyone, especially not his son, especially not anyone under the age of 18. I don't believe that's appropriate to keep that on there.
All right. Well, the nature of the charges, as well as the relationship between the defendant and the complaining witness, I think merit those bond conditions. So I'm going to deny your request. All right. So thank you, Mr. Schmidt. I've done a scheduling order. We will get that out to Mr. Murphy. Make sure you stay in contact with Mr. Murphy. Thank you.
Thank you, Your Honor.
So, all right, who do I have joining me from the jail?
Opal.
All right, Mr. Opal, let me grab your file. So this is in the matter of the people of the state of Michigan versus Jason Frank Opal, file number 23-21508FH. I have Rhonda Underwood appearing on behalf of Mr. Opal, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for pretrial. Ms. Underwood, how would you like to proceed today on behalf of Mr. Opal?
I believe it's set for arraignment, Your Honor.
Oh, I'm sorry. This is a date and time set for arraignment. So Ms. Underwood, do you waive the reading of the felony information?
We would waive the reading of the felony information, Your Honor, acknowledge its receipt and the receipt of the witness list and request for discovery, and ask the court to enter a not guilty plea on Mr. Opal's behalf at this time, Your Honor. I believe, Your Honor, that this case will not take long. I would ask for a very quick pretrial in this matter, Your Honor.
Well, I will enter a plea of not guilty on behalf of Mr. Opal. And my next available pretrial is October 4 at 8:30 a.m.
Thank you, Your Honor.
All right. My office will prepare the pretrial notice because of the arraignment. And Mr. Opal, we will see you back on October 4 at 8:30 a.m. All right?
Yeah, can you come talk to me, Miss Underwood?
I will, Jason. I'll Zoom you. Okay.
Yep.
Mr. Opal, would you do me a favor? When you go back, will you let them know I would like to see Mr. Goff, Goff next, if I could.
I will. Thank you.
All right, thank you.
No.
Thank you, Jason.
Okay.
Yeah. You can Zoom me now or later?
Not right now.
Because we're busy. It'll be later.
Thanks.
All right, Mr. Glazier, in the matter of the people of the state of Michigan versus Derek Jackson, look at his file. File number 21-20643FH. This is, I don't have Mr. I don't know what's going on. All right, so let's see. Court of Appeals reversed his conviction, remanded for a new trial. Okay, so that's from July, and Mr. Jackson will be appointed counsel for retrial. So I did the order for court appointed counsel, and is that you, Mr. Glazier?
That's me, Your Honor.
All right, so I have a notice of hearing to appear for today, but I do not have a writ, which I'm gonna guess. I have Court of Appeals record clerk. Let's see, they still have my file. All right, so I do not have Mr. Jackson here today, and I'm going to guess this is the first notice. This is the first notice that the people have had on this as well. So, Mr. Glazier, I guess I'll have Christopher Fleming on behalf of the people. So, Mr. Glazier, would you like it set for a pre-trial and then a writ done to get Mr. Jackson here?
That'd be fine, Your Honor.
How far out would you like a pre-trial, Mr. Glazier?
It doesn't matter. I've never met with him, so probably fairly quickly, I would guess.
Well, I think me and Miss Underwood have met him. All right, so how about October 4 at 8:30, Mr. Fleming, that would give enough time for the people to do a writ.
Yeah, that should be fine, Judge. My thoughts would be, with this went to jury trial previously, it might be advantageous and to keep it within timeframes for prisoners if we set it for, as a backup at this point.
You're talking about a trial?
Exactly, Judge.
Mr.
Keep that October
Glazier?
18th, October 4th date, excuse me, but
I'd prefer not to set it for a trial till I have a chance to talk with him, but
Okay, so why don't we do the October 4 pretrial? That's like 30 days out. I believe he's serving life on another charge. So he would take precedence. So I could set him for a trial probably fairly quickly at that point, Mr. Fleming.
fair enough, Judge.
Okay. All right. So people would do the writ. My office would do the pretrial notice for October 4 at 8:30 in the morning. Miss Adams, if we could do that. And we'll see you back on Mr. Jackson that day with Mr. Jackson. All right.
Thank you, Judge.
All right. Thank you.
thank you.
All right. So let's see what we got. And Mr. Daniel Michaels. Joe. I think everybody I have left is in jail. And I got one jail window, so we're just waiting. I'm gonna take these files to Miss Becky, and I'll be right back.
Angela was calling for Goff, and we kind of throw it in there. No. Yeah.
All right, Mr. Goff,
Good morning,
how are you
Judge.
today? Good morning. All right, Mr.
As good as can be in a jail, so, you know.
I'm sure. All right, Mr. Noe, I'm sorry for the delay. This is in the matter of the people of the state of Michigan versus James Goff. File number 23-21365FH. I have Mr. Noe appearing on behalf of the defendant and Ms. Wagner appearing on behalf of the people. This is the date and time set for pretrial. Mr. Noe, how would you like to proceed today?
Thank you, Your Honor. If I could have a brief breakout session with my client, please.
Of course. So I'm going to open up a breakout room And I'm going to.
Do I need to do anything?
In 1 minute, so hold on, I'm closing because I had a bunch of breakout rooms open. So I'm gonna close them. I'm gonna put my hallway in the waiting room. And then I'm going to open up some breakout rooms. All right, so now I'm going to put you and Mr. Noe into a breakout room. You should get an invitation to join.
Oh, okay. Thank you, Judge.
Thank you. so Mr. Noe, how would you like to proceed today?
Thank you, Judge. On this matter, I spoke to Ms. Wagner about this. Actually, Ms. Wagner, I've talked several times about this, as a matter of fact. She is offering this matter for my client to plead guilty to domestic violence first offense, with a dismissal of the second or the third offense notices, I guess second offense notice as well. That's what my client wishes to avail himself of.
Okay, all right, very good. Mr. Goff, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name for the record, please?
James Henry Goff Jr.
Very good. You can put your hand down. All right, so Mr. Goff, you have heard the statement of your attorney. Oh, I'm sorry, Ms. Wagner, is that a correct recitation of the plea? He would plead to count one, domestic violence, without the third offense notice?
Yes, Your Honor, thank you.
Okay. All right, so Mr. Goff, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to domestic violence, which carries a maximum penalty of up to 93 days in jail and or a $500 fine?
Yes, Judge.
All right, are you satisfied with Mr. Noe as your attorney and the advice that he has given you?
I'm more than satisfied. Thank you very much.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Noe?
Yes, Your Honor.
And Ms. Wagner?
Yes, Your Honor.
And Mr. Goff, as far as you're aware, is that correct?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. I'm sorry. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Goff?
Yes, Judge.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Judge.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Mr. Goff, do you have any questions about the rights that I've given to you?
No, Judge.
All right, how do you wish to plead to the charge that on or about April 29th of 2023 in the city of Tecumseh in the county of Lenawee, that you did commit the offense of domestic violence? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Okay, do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Noe?
No, Your Honor.
And Ms. Wagner?
No, Your Honor.
All right. Mr. Goff, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Judge.
Is it your own choice to plead guilty?
Yes, Judge.
All right. So, Mr. Goff, on April 29th of this year of 2023, were you in the city of Tecumseh in the county of Lenawee.
Yes,
And at that time, were you in the presence of your wife who has the initials of JG?
yes.
All right, and so did you assault her or strike her, or tell me what you did to her?
There was an argument, like so many times before, about our divorce.
Okay, so I don't want you to minimize. I want you to tell me what you did.
Oh, I threatened
You
her.
push her? You what?
I threatened her, yeah. That I.
All right, did you touch her?
I grabbed her wrist.
Okay, so you grabbed her wrist without her permission,
Correct.
and that would have been an assault. Would you agree with that?
Yes,
All right, when you grabbed her wrist, did you push her, pull her, knock her down?
no,
Ms. Wagner?
Your Honor, I'm satisfied. I mean, that's, Mr. Goff, did you push her when you grabbed her by both of the wrists?
yeah,
Okay, I'm satisfied with that, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Noe?
It has.
Ms. Wagner?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the district court probation department for a pre-sentence investigation. I am going to set this matter for sentencing. Mr. Noe, are you available October 20th at 8:15?
Yes, I am.
All right, hold on a second. October 20 at 8:15. Mr. Goff, how long have you been in jail?
since July 21st. And,
Right.
I'm scheduled to be released February 17th, I believe.
Okay, so you're in jail on something else, is that correct?
Drunk driving from last year and an issue with my now ex-wife. You divorced us here July 24th. So yeah, she's my ex-wife now.
Okay, all right, okay. So I will set this for sentencing on October 20th at 8:15. Who is your probation officer down in district court?
Her name was Liz, I think Westfield.
Okay, all right, so someone from district court probation, since your probation was probably terminated, it might be Mr. McCarron, will come over and meet with you, be truthful about your background, the events that occurred. They'll prepare a report. They'll provide that to us. We will provide that to Mr. Noe, if hopefully in time for him to meet with you before. If not, he'll talk to you the morning of, and we will see you back on October 20th at 8:15. Now, Mr. Goff, do you have any objection to appearing via Zoom?
Oh, no, not at all, Judge.
Okay, so that'll be via Zoom. And, all right, so we'll see you back on that day. Thank you, Mr. Goff.
Your Honor, I would like to address Mr. Bond if we could, please. My client is currently, as he indicated on the record, serving some time on a violation, something like a drunk driving case, perhaps. I could one way or another, but on this matter, I checked with the court staff earlier this morning. My client's on a PR bond on this matter. I would ask the court to place a bond on this matter, $500 or whatever the court sees fit, so that my client would be receiving credit.
Ms. Wagner.
Your Honor, I guess, and I don't know if you can answer this question right now, but I would like to understand what that would mean for sentencing.
Well, if I change his bond now and I give him 90 days in jail, he'd have a credit for time served. Although technically, well, I don't know how it works with misdemeanors anymore, but you know, he's serving time on the violation of probation for something that he was on probation for at the time this offense occurred. So technically I could, I guess, stack the sentences maybe, but it would just mean if I give him jail time, he would get credit for the next 6 weeks. And almost max out.
Right, and so then there would not be a probation term, is that my understanding?
Well, there could be probation, but
I'm sorry, you're cutting out a little bit. Did you say there could not be?
Well, it's a 93-day misdemeanor he pled to. So, you know, credit for time served is what, 5 days a month, so 15 days. So, you know, he wouldn't have his full jail time in, but are the people looking for probation and no upfront jail in light of the fact that he's doing all this jail time now?
So this is what I'm gonna say, and I made the offer to Mr. Noe earlier. The people were willing to Killebrew to no additional upfront jail. My primary concern here is accountability for Mr. Goff and ensuring that there is some measure in place to, I guess, motivate him to not have continued contact with the victim in this matter. There have been multiple incidents between these two. I am concerned for her safety. And I guess I want some kind of mechanism in place that will help to ensure that he will not have contact with her. So my preference would be a probation term with a no contact order for the duration of that term.
All right, so you're not looking for any jail time on this offense? Because
we're not asking for that.
All right. So Mr. Noe, in light of the fact that he's not going to get any jail on my sentence at this time unless he violates, I'm going to leave the bond the way it is.
Your Honor, I would ask though that if his bond is amended, I would ask that the bond, I just want to, for the purpose of the record, I would want there to be a bond effective July 20th so that he get credit from the time he's incarcerated going forward. Because my understanding is that client is entitled to some sort of bond in this matter.
Well, he has a PR bond.
At this time.
I mean, well, it's not my fault. He committed a domestic while he was on probation for those other things. But since there's no jail on my offense, I'm not going to change his bond. All right, thank you. I'll leave him with a PR bond.
Okay, at that time, Your Honor, I guess I would want to, I guess, I don't know if I file a motion or can address that this time in the court. I'm not, based on the court's ruling on bond, I'm not sure my client wants to accept the plea at this time based on.
So he's not getting any jail on my case. There's a Killebrew agreement that he's not going to get any jail on mine, but I don't want him to max out because the prosecutor wants him to be on probation.
We've not agreed to any Killebrew with this, that's been placed on the record at this time.
So do you want me to consider jail time for him at the time of sentencing?
I would, at the time of sentencing, well, Judge, it depends. I'm going to put a bond on him at this time because now he's doing all this dead time, and then we get to the day of sentencing. I guess at this, I would. I don't know, Judge. I don't know. I'd have to discuss that with my client. This is a new development, so I don't really want to make that call.
Well, I mean, he's not entitled. Hold on a second. So he has a bond. Whether or not he's got a sentence on something else is irrelevant. You know, I'm not planning on giving him any jail on this offense because we want him on probation. So, Mr. Goff, do you understand that people aren't asking for jail at this time?
Yeah, and quite frankly, Judge, I would rather do the 93 days because I'm planning on leaving the state when this case is over. I'm all set to go to Florida.
So, Mr. Goff, are you asking to be maxed out on this offense?
Yes, please.
And you don't want to do probation?
And I'm willing to give a PPO if that will satisfy the prosecutor. A PPO for the rest of our lives. I will not communicate with her. This has been a nightmare for me, Judge. All right, stop talking now, Mr.
Goff. Mr. Goff. So, Ms. Wagner, he does have a right to ask to be maxed out at the time of sentencing because probation is a choice. So if he's asking to be maxed out, then there won't be a probation term, but he's willing to agree to a PPO.
if he's going to be maxed out without credit, I mean, it sounds to me like he wants you to give him credit for what he's serving and has served on other offenses, and he wants no consequence for this particular incident, which sounds great. You know, if I were him, I guess I would want that too. But also the victim has a right to have input into the sentencing as well. And
well, not if he's asking to be maxed out. So if he's asking to be maxed out, he has the right to do that. And I would change the bond as today. So his 93 days would start ticking today.
okay, and that I don't necessarily have an issue with. And I just want to state that either way, the victim does have a right to be heard at sentencing.
She does, but he also has the right to refuse to do probation and be maxed out.
Understood.
So, okay, so I'm gonna write in here, defendant has to be maxed out. All right. Okay, so I'll change your bond to $100 cash bond today. And we will see you back for sentencing on October 20th at 8:15. All right?
Thank you so much.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Be in touch, Charles.
All right, and Mr. Goff, could you
Yes,
let
ma'am.
the jail know that I would like to see, let me see. Let the jail know that I would like to see next, Mr. Lauro, Tiffany Schermacher. Can you do that?
Schermacher?
Yes, sir.
Okay, you bet, Judge. Okay,
Thank you.
thank you. Okay, she wants to see Schermacher. Okay, thank you very much.
Thank you so much, Judge.
You're welcome, Mr. Malaro. Hi, can I ask your name, please?
Oh, man.
What is your name?
Hello?
Hi, what is your name?
My name's Kevin Schultes, ma'am. I messed up. I came to work today and forgot about my court date at 8:30 this morning.
Okay, you're okay. You're good.
Oh,
Hold on a second. Hold on.
Okay.
You're fine. Mr. Jagger Margosian is here and we are good. So hold on.
Okay.
All right. This is in the matter of the people of the state of Michigan versus Kevin Bruce Schultes, file number 22-21060FH. Mr. Schultes, we are here. We are here today on a pretrial conference as well as a contempt of court. I have, I need a prosecutor. Who's my prosecutor? I have Mike or Allison Arnold appearing on behalf of the people. And I have Michael Jagger Margosian appearing on behalf of Mr. Schultes. Let me get back to that contempt of court. The contempt of court that's been riding along is failure to appear for a pretrial on May 31 of 2023. So, Mr. Jagger Margosian, how would you like to proceed today on behalf of Mr. Schultes?
Your Honor, regarding the contempt of court, I'm seeing that Mr. Schultes pled to that on 8/29 last week and was sentenced to credit for time served. So unless I'm mistaken, I believe that contempt should be.
You're right. Okay, that's fine. It just, for whatever reason. Okay. So with regard to his pretrial though, how would you like to proceed?
Your Honor, regarding the pretrial, if the court would recall, we adjourned this to allow Mr. Schultes to go to the prosecutor's office and comply with the ETU terms and mainly pay the amount. I don't know if that's happened, I guess if I can just ask Mr. Schultes, what's the status
I
of
did.
that?
I paid $500 to them. It was last week sometime. It wasn't as soon as I got out of jail because it was noon.
All right. So Mr. Schultes, hold on a second. Ms. Arnold, can we verify whether he made the payment to the economic?
Mr. Wendt is out this week due to a death in the family. So could we please put it over maybe 2 weeks, and Mr. Dagger Margosian can get with our office and we can try to verify that.
Okay, so what I'm gonna, Mr. Dagger Margosian, can I just set this out to?
Of course.
Like September 27?
Yes, thank you.
All right, Mr. Schultes, I'm going to adjourn this pretrial to September 27 at 8:30 in the morning. Can you write that down?
I am right now, ma'am. Yes.
Okay, so you're gonna zoom into the
27?
same number, September 27, 27
Yeah.
at 8:30 in the morning.
Okay.
And Mr. Dagger Margosian, can you do the step in order to adjourn?
Yes, Your Honor, thank you.
And sign my
Ms.
name.
Arnold?
Yes.
Okay, all right, very good. All right, Mr. Schultes, we'll see you back September 27 at 8:30 in the morning, all right?
Yes, ma'am. Thank you, ma'am.
All right, thank you.
Ooh, yes.
Is that Leo with you, Mr. Malaro?
Did you talk to me, Judge?
Yeah, is that Leo
How's,
hanging over your shoulder, telling you what you need to do?
Yeah, he's my mentor.
We all need one. All right, Mr. Dagger Margosian, I apologize. I don't know what's going on with the jail today.
That's no
But
problem.
I'm gonna call the jail.
I'm here all morning, Judge.
Me too.
Mhm.
All right. Hi, Leo. Maybe they're getting the Schermacher. Okay. Give them a minute. So the only thing I have left is Tiffany Schermacher with Mr. Malaro. And then I have John Dotson and D'Angelo Williams with Mr. Dagger Margosian. So. Hi, this is Judge Anzalone. I still need 3 more people. I need Tiffany Schermacher, John Dotson, and D'Angelo Williams.
Tiffany Schermacher, John Dotson,
D'Angelo Williams.
Alrighty.
Okay, thank you.
Bye.
Bye.
There you go. Thank you. You're welcome. Yeah.
All right, Miss Schermacher, let me grab your file. All right, this is in the matter of the people of the state of Michigan versus Tiffany Renee Schermacher, file number 23-21338FH. I have Salvatore Mallara appearing on behalf of Miss Schermacher. And I have Allison Arnold appearing on behalf of the people. This is a date and time set for a pretrial in this matter. Mr. Malaro, how would you like to proceed?
Your Honor, I'd like to adjourn this for another pretrial. We'd also like to establish a COBS conference in the near future. We're going to meet with Ms. Arnold tomorrow about Ms. Schermacher and then go speak to her. And then hopefully we can do the COBS conference.
Okay. Okay. So when are you speaking to Ms. Arnold?
I'm going to meet with her tomorrow. Tomorrow after my morning docket.
All right.
She said she's available, so I will find her.
Do you all want to meet at 11 o'clock tomorrow?
Well, yeah, I could do 11.
Does
Do you
that
wanna
give
meet-
you time to meet with me first, Sam?
Well,
Yeah,
you guys can meet in my jury room and talk, and then I could come in and talk to you. We could just kill.
Okay.
Yeah, I have 3
It all off?
sentences tomorrow, and then I have a 9 o'clock probable cause. So I should be.
That sounds good.
I'll pop up after I'm done.
Okay. So, all right, so we can do that. And so we'll do a COBS conference at, let's see, September 7 at 11. And then I can do a pretrial with Ms. Schermacher. September 13th. Would that be good, Mr. Malaro?
Yeah, I'll right after the COBS, I'll go talk to Ms. Schermacher.
All right, so we'll do. So pretrial conference September. I guess it's September 13. And that will be at 8:30 a.m. So Mr. Malaro, can you do the step in order to adjourn?
I will, Your Honor, and the COBS as well.
Yep, and then I will see you guys tomorrow at 11. All right.
Thanks, the judge.
And
All
I will
right, thank you.
see you tomorrow, Stephanie, okay?
Thank you.
Yep.
All right, Ms.
Yeah.
Schermacher, could you let them know I'd like Mr. Williams or Mr. Dotson next?
Williams or Dotson?
Yep, thank you.
Thank you, Judge.
Thanks, Mr. Malaro.
have a nice
So, you too. All right, so that leaves Mr. Dagger Margosian. Hopefully we'll get your people.
I heard you spoke up. Yeah. Your grandma.
I'll be back. Becky,
Yeah.
the, is that Mr. Norton? Whatever his name was, that was in here. I told you about the fingerprints. Well, supposedly, when he was in here, he left his.
Oh, I'll send it.
Okay. Thank you.
Guys, we're still live on YouTube, so. Mr. Dagger Margosian, it should just be another minute.
It's no problem, Your Honor. Thank you.
Thanks. Well, it is kind of a problem because I have another hearing at 11, so. But. All right, Mr. David Margosian, I'm gonna go off live stream to do my 11 o'clock hearing, and hopefully we'll get somebody from the jail, and I'll go back on